Hi, I'm Madison Kelly. I'm a Senior Associate and Accredited Specialist in Coleman Greig's family law team. After a couple separates, one of the first things that they might need to think about is how do they divide their property. There's no one-size-fits-all for dividing property between parties, and there are different variables that will send a matter in a different direction. But generally, there is a process that the court will follow. When I say court, that doesn't necessarily mean that you might be in court. Often parties won't see the courtroom at all. But family lawyers are obviously giving advice based on what the court might do. So in relation to dividing property, there's essentially a 5-step process. The first step is, should the court do anything at all? If it is the case that the parties have not been together for too long, they don't have children, or they don't otherwise have joint assets, the court might decide that there's no use in adjusting their property interests at all. If, however, the parties have been together for some time, they have children together, and they own joint assets, more than likely the court will decide that an adjustment needs to be made. So typically this step is easily overcome. The second step is identify the asset pool. That is, what is there available to divide? This process can take a little bit of time. This requires exchanging financial documents, going back and forth, and basically disclosing what it is that each party owns and owes. Once that's all worked out, there'll be a balance sheet which allows you to work out what it is that the parties have to divide between them. This process often also requires valuations. It may be that property needs to be valued, that can be real property or commercial property. It may also be that businesses need to be valued. It could be various other ancillary items and all sorts of things like jewellery, handbags, as much as you can think of. Once the asset pool is identified, the court needs to basically work out, well, what do we do with it? The court then looks at contributions. What contributions did each party make to the relationship? Those contributions are broken down into subcategories. Effectively, the first one, initial contributions. That is, what did each party have at the start? Did they own property at the commencement of the relationship? Did they have debts? What was their initial net position? Once that's ascertained, the court then looks at contributions during the relationship. Those contributions can be both financial and non-financial. Financial contributions are things like income, gifts from family members, inheritances, windfalls if anyone was lucky enough to win the lottery, and other injections of finance. Non-financial contributions are things that you can't necessarily quantify but have added value to the relationship or the party's asset pool. So that may be things like parties using their skill and labour to renovate a property, or otherwise exerting their skills in a way that has added value but didn't necessarily inject direct funds into the pool. Once the court has ascertained what the contributions were during the relationship, the court will look at what happened after. These are the post-separation contributions. Often, parties will decide to separate and commence a property matter fairly quickly, and that makes this step quite simple because that period of time that has passed since separation is not particularly lengthy. In other situations, some people do take some time to take that step, and the period of time post-separation will be more lengthy, and that process will become a little more difficult. Post-separation contributions are things like who paid the mortgage after separation, who primarily cared for the children, did either party receive an inheritance or some other gift or financial injection after the relationship ended, and those are the things that the court will consider at that step. Once the court works out the totality of contributions, the court will then go to step 4. Step 4 is work out what are the future needs of the parties. What does each party need into the future to enable them to support themselves? Is there an adjustment that needs to be made for one party? Relevant future needs factors are things like age, health, care of children. That doesn't just have to be care of the children of that relationship, but can also be other children that a party may have from a previous relationship or even a relationship thereafter. Income earning disparity is also a significant factor that often sees the court decide that an adjustment is warranted for one party. It's not unusual for one party to go on and earn far more than the other party, and in those circumstances, the court will make an adjustment to ensure that, in essence, the parties are on some form of a level playing field. The last step is step 5. Is it just and equitable? I like to call this the does it feel right test. It's the last step in the process where the court needs to decide is the agreement in all of the circumstances, considering the asset pool available and the contributions made by each party, just and equitable. Often that looks like a percentage. If it's the case, for example, that each party is receiving 50% of the asset pool, on its face that may seem like a just and equitable outcome. But the court doesn't just look at the percentages, it's also about the mechanics. So consider a situation where the parties are retaining an equal amount of the asset pool, but one party might be receiving all cash and the other party might be receiving all super. It may be the case that the asset pool's divided equally, but it might not meet that does it feel right test. If you're contemplating a separation or you have recently separated, it's important to get advice early. Speaking to a family lawyer will enable you to get the right advice to navigate your property settlement.